Hi, just helping to set Georgia Kramer up.
Hello.
Oh no, I can't hear you. One second.
Because
There
I
you
had, yeah, there I am. It's on my end.
go.
I'm trying to remove something. I have this recording thing that I think I want to stop. It's like my note taker, and for some reason it's not. Eesh. All right.
Okay, Georgia will be with you in just a few minutes. You start at 9, right?
At 9, yeah. So thanks for coming. Thanks for, does she need to share a screen or anything? And what's your first name?
Oh, my name's Marina.
Marina. Marina, does Georgia need to share a screen or anything?
I don't believe so. But she might. She just left the room, so I don't really know. I know that she's taken some notes. Um, I don't think she'll need to share a screen. Is
Okay.
that okay?
Yeah, that's okay because I am not, I usually am the host of the meeting and this is through the NYCP site. And I don't think I have the ability to do that. We need to figure that out. Okay,
Yeah. No, I think she won't be sharing a screen.
okay.
I'm trying to see even within Zoom how you would do that. Is it only that the host could do it?
Yeah, I think so. Yeah, and I don't
Okay.
know.
I mean, I see that there's a whiteboard, but no, I think it'll be fine. Okay, I'll go find her. I'll be right back.
Thank you.
I'm just meeting after. What do our keep on?
Hi there.
Oh, hey, how are you?
Just great. How are you?
I'm doing okay. Yes. So thanks for joining this morning. I don't know how many people are going to be coming. It's always surprising because it's like a link for like I didn't even register, to be honest with you. I had to get the register from thing, but people register for the year, Georgia. That's the thing. So I
Oh,
never know who's going to come, but we did get a few. And the topic is always a ripe one for discussion.
okay. Could you put the I in IRA? Thanks. The
Okay, well, you
topic
look
is
good.
scary. The topic is absolutely scary.
You know,
I've been reading all these malpractice cases,
oh, really? Oh my goodness.
and yeah, it's. I didn't realize quite how scary it was till I started preparing.
Oh my God. Yeah, that's I know that's why we have to work with certainly quadro preparers that are competent and
Do
good.
you know any?
After Bob Guarnera passed, it's been a void that I don't believe has ever fully been filled.
I was talking to Matt last night, and he said, "Why is there suddenly this crisis?" And I said, "Well, but the person we all turn to retired, and we haven't replaced him. In addition, the plans have stopped providing the information to the preparers. So
Mm.
yes,
Mm,
It's really an extraordinary mess. That's-
yeah, that is. I know, Carolyn D'Agostino.
She was the one.
Yeah, but so she's now working, I think it's her husband, I'm not sure, Robert Jones, or is he just a colleague? I don't know. I get very confused, but they're up in Albany. But they're like super busy. I don't know. It's hard to get.
I thought she was ill and wasn't doing it.
No, she had like long COVID. She's back. I thought she retired, then she went back, but she's working with a firm up in Albany, Robert Jones. Again, I don't know if it's her husband, some kind of family. It's like they branched out into their own firm. And they're both he's an attorney as well. And I think that's a key. Working with a quadro preparer who's also, I mean, it helps that they have that
And
background.
beyond that, you need an actuary somewhere along the line.
Yes, 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 yes.
Lexington does not have actuaries.
Oh,
I,
hey, good morning, Stephen.
hey, Stephen, I called them to ask. No, they don't have him.
And Tova also is
I
not,
think she's not an actuary, but she may have one working for her.
yeah.
Sure. So,
Yeah, so we'll talk about that.
yeah,
I'm having an issue now that I'm trying to get, and maybe you'll speak to this. A quadro done before the divorce entry that's already
Good
been
idea.
pre-approved. And I've been getting, I
which,
had
which court
success.
are you in?
Well, it was in Westchester. I got one through.
Yes.
I got one through in Putnam, but now I'm trying to get one through in Westchester with Judge Fiore. And she's like requesting, they already reached an agreement. They have it pre-approved. They're the quadro, and she's refusing to sign it. And wants like I have to go for a preliminary conference, which I've never done, Georgia, in 30 years.
I'll come with you. Melissa, I'll come with you. This quadro got through in Westchester and Putnam because I convinced Judge Fredman that it was allowed.
You think you
Years
can
and
come
years
with me?
ago.
I haven't done
We'll
it.
come with you.
Okay. Well, let's talk offline after this because I don't know what to do. I don't think it's right that they have to file, get the divorce.
Hi,
Hey, Andrea.
Andrea, you're still talking to me.
Yes, I'm gonna go on mute though. I'm having an IT issue, so I have to pick up my IT guy, but I'm here. Hi.
Hi. Okay, so because
All right. So welcome, everyone.
hi everyone. Okay,
Guys.
should I just begin or
Oh
it's
God,
not
you're
9
prompt.
yet?
Yeah, you hold
not
no
9
wrong
yet,
here.
no.
It's 9 o'clock. Let's begin.
Oh.
Okay, give me like a minute.
So
Just people are
shiny
coming in.
faces looking at me. I don't know how long I'll keep them. So I figured I better start.
Okay, yeah. Well, you could. I
Yeah.
just wanted to welcome everyone. Hey Sherry, good to see you. I can still say Happy New Year if I haven't seen some people.
Almost
So
happy, yeah, it's mid-month,
Yes.
but Happy New Year. Hi, Melissa. Good to see you.
yeah, good morning. So I never know how many people are going to show up to this, but we have at least 6, and Georgia's ready to go.
Well,
And she
okay,
has
we
a
wait.
wealth. Yeah,
A few
but
minutes.
I know there's so much information to share. Hey, good morning, Alan.
Hello, Alan.
Good morning.
Good. Yeah, so I think I've done all of you from my collaborative chats except Georgia and Sherry. So I want to follow up with you. I do these collaborative chats with all the members of our organization, and I haven't gotten to you, Sherry, and Georgia. I haven't gotten to you, although I've chatted with you a lot, but not officially.
Oh, I'm an unofficial.
If you're interested, let me know. It's like a 15-minute chat, get to know you, and it goes on the NYCP website, and it's just a way to our members to connect with each other and learn a
We
little.
did it yesterday with Melissa. It was a lot of fun.
It was fun. Yeah.
I'll
I have to
email
go
you,
over it.
Melissa.
Hi.
And Georgia, you have the right to edit.
You have the right to edit. You can enhance, you
In
can do
that
anything
case,
you want.
I'll be on for hours.
We'll get it in a couple of years. Yeah, I did it with Stephen. I learned a lot about Andrea. I did it with, yeah, it's a fun thing. I enjoy it. Okay, I have to do Kathleen too. Hey, good morning, Kathleen.
Hey there.
What do you mean you have to do,
Yeah,
Kathleen?
I did. I was talking about most people.
Have to let you in.
Oh my
I've
God.
been waiting to hear that for a long time. Go ahead.
We were debating whether to let you in.
Okay.
No, I do these collaborative chats and I was noticing I've done a lot of people in this room, but I have not done Sherry, Kathleen, and Georgia. So you're on my list. If you would like to, I'd love to.
Oh,
Do we get to interview you?
I taught my first class at Pace last night, and
Oh,
it's matrimonial law, but it's the practical, and it's just so invigorating. I always think, do
Oh.
I really want to do this?
that's
You know,
amazing. That's amazing. How big is your class, Kathleen?
we limit it to 16,
Wow.
but there's been lots of people that wanted to join over the 16. So yeah.
That's
Is
amazing.
that the basic introductory matrimonial law class, or
No,
is it a?
I don't even know, Alan. It's what uh it's a practical. Well, I did the curriculum, the syllabus, and you know what I tell the kids is when I got out of law school, I didn't know the difference between an order to show cause and a motion, and I had never. So it's very practical. It's kind of like, you know, DRL in a nutshell, and then we do a lot of uh on and on, you know, hypotheticals. And I invite 3 judges, and they're so generous. So their final paper is to do a motion, pendente lite motion, and to argue. And Judge Dillon, Judge Koba, Judge Jameson, they all come to judge the motions. So it's a fun course.
Yeah, that's fantastic. You want to get the practical experience other than just knowing the DRL. That's great.
Yeah.
And
Yeah.
if they listen to me, they'd all run.
Melissa, can I interrupt for a second just to make a plug
Yes.
for
Go.
the NYACP and the Westchester Women's Bar Association is having a networking event at the Brazen Fox on February 6th. So
Yeah.
you can sign up through either the WWBA or the NYACP website. Shara Goldfarb is leading the charge, and we're looking to max out. We have a lot of sponsors. It's really getting, if you know anyone who's interested in collaborative law, get them to come. We're trying to get newer practicing matrimonial attorneys to sign up. We're marketing it, you know, multiple counties. I'm lobbying the Hudson chapter to come down, New York, Long Island.
What's the
everyone come.
capacity?
Pardon me? You know,
Limit.
as many as we can get.
No limits, Georgia.
I don't think
Okay.
there's a limit. We'll go over the limit. It's going to be fun, but please sign up today. We really need members to sign up. Thanks.
Okay.
Sure.
I just wanted to mention that Melissa was on the board meeting, as the former president of the NYACP, and they're giving a discount for
Yeah.
people that for Westchester Women's Bar Association members who sign up within 30 days to become members of the NYACP. And I love the cross-pollination. So, you know, the women's bar might consider a discount or some incentive for NYACP members who are not members of the WWBA to join.
Sure, Kathleen, and I need to get that discount out that the NYACP is offering. So I think I should do a standalone blast or something like that, or maybe we could call all the mat attorneys in Westchester and get that out to them to say
Yeah.
join now and you get a discount.
Yeah, why don't you also have this with Sarah, who's the executive director, just CC her on that to make sure that you have like the code and just to kind of run it through her.
Absolutely, that's
Yeah.
huge. That needs to be advertised, so I need to
For
get
sure.
on that.
For sure. And
In
then
your spare time.
yeah, and during the day, just to let you know, on the 6th, we just have a double event. It's but not to take away, but if anyone wants to take the day off and go to for the Racial Equity Committee of the NYCP, which I'm doing with Catherine Canaday, we're taking a little field trip to the Whitney Museum at 11 o'clock in the morning in the city. So a full day of little networking and culture and, you know, on February 6th. So we're looking forward to that. And I'm definitely going to see you in that evening too. So thanks for facilitating that. Without further ado, Georgia, you know,
Okay, here we
no
go.
introduction needed. Do I need to do your bio? I mean,
Oh, I love
you're
hearing it.
yeah,
Because
well,
I don't remember it.
well, you're a legend. I can't even, I didn't even,
Okay,
you know.
guys, listen, the retirement assets we have a huge problem. I've been preparing for this because I had a rather interesting case, but the cases are legion with malpractice. And usually there's no malpractice found because of the statute of limitations, but there's definitely malpractice in the sense that our quadros are not adequate. And there was a very recent case where somebody said, oh no, I don't, that's not my responsibility. My retainer was for the divorce. It ended with the judgment of divorce, and I don't do the quadro. Well, the court said, yes, you do. You did not spell out to this client that quadro was needed and was not part of your retention. And it is clearly your responsibility. You can't walk away from that responsibility by saying your job is over. So we have a big problem in that we need people who are competent to do quadros and IRAs. And at this moment, we have very few. We thought we were better off, but now that we have case law about Majauskis, we're in deep trouble. We miss Bob Guarnera, and all of us are looking for ways to not make mistakes. What I discovered this week is that Majauskis is a mistake. That if we say this is going to be divided pursuant to a Majauskis formula, we are probably screwing up, because Majauskis doesn't cover things like death benefits, survivorship, what happens with 2 wives or 3 wives. And if you say it's in accordance with Majauskis, it's different all the time. And we don't know what is comprehensive. So we need to have people who train with us, who tell us, look, when you do a quadro, this is what you have to cover. And if you cover just Majauskis and the formula, you're wrong. And there are a series of cases saying this is not included and that's not included. Now, you have to have it in the agreement. The division of these assets have to be part of the stipulation of settlement. They cannot be added later unless it's by stip. But what the court is limited to is what it says in the stipulation of settlement. So if somebody comes back and says, but I didn't know he had this incentive bonus, we can't change it without the other side. So all of these horrible cases are saying the attorney is at fault, but because the statute of limitations is 3 years, we usually, fortunately, get away with it. The fact is, we need to know what we're doing. Now, we usually think that the IRAs are simple, and they're much easier than the quadros. So if a person has an IRA, how do we divide it? What we have is the Internal Revenue Code, which says that the transfer of an individual's interest in an IRA to his or her former spouse under a divorce or separation instrument described in IRC, etc., is not a taxable transfer. Okay, so we start out thinking transfer between spouses not taxable. Totally wrong, because every word in this statute leads to a whole line of questions of what is taxable, what is incident to a judgment of divorce, how can we make it non-taxable? Usually a transfer between spouses, 1041, tax-free transfer. Exception, transfers from retirement accounts. They are not covered by 1041. They are covered by 408D6, a section that's becoming very close to my heart. For a transfer from an IRA to be tax-free, you have to go through this statute almost word by word. the transfer, okay, we can sort of handle that, of an individual's interest. Now, what the heck is an interest? You'd think we know it means part of, but for the statute, it doesn't. An interest means a part of the ownership. But it is not just it is not the assets within the ownership. It is an interest in the IRA in total, or as a significant, or as a portion of the IRA. But it is not just assets coming out of one account and going into another account. So we have to deal with this word interest. And many of the transfers, if they do not consist of the person's portion of the entirety of the account, it's not tax-free. It's a problem. It must be the interest. If the assets have come out and been invested and then put back in, or if they're withdrawn and transferred to somebody else, like a spouse or a secretary, then it doesn't qualify as a tax-free transfer. Tax-free transfer has to be from an account of which you own a portion, not once you take it out. And then if you take out the asset, leave it out for 20 days and then give it to the spouse, it's not tax-free. It has to be a direct transfer of an interest. This word interest is a killer in the account. So I'm talking now about IRAs, and almost every word in the statute is a trap. So it has to be an individual's interest. Individual is another trap word, and it goes directly. So it goes from the owner, from the trustee or custodian for the owner directly to the next owner. So it goes from the husband's interest to the wife's interest without an interruption. Like it doesn't go from the husband to the wife's lawyer and then to the wife. It has to be a direct transfer of an interest in an IRA. Okay, then it goes to your spouse or former spouse. We're sort of okay on that. Under a divorce or separation instrument described in a certain section, IRC 71B2A, in order to be tax-free. The transfer of an individual's interest to his or her spouse or former spouse under a divorce or separation instrument. Now, here's the catch. It doesn't say under a separation agreement. That's in paragraph B. So we are not sure whether a separation agreement that is not converted to a divorce would allow something to be tax-free. And the secret of this is this section 71B2A. A is the difference between having it taxable and having it not taxable. So it's this subsection. And we have to make sure, because we don't know if it has to be incident to a divorce. And incident to a divorce means under a divorce or separation agreement, which is described in A, which means it doesn't include only a separation agreement. That's B. So that's why we say, let's make sure you get divorced before you do this with IRAs. This doesn't apply to 401ks. This is the IRA section. So the IRA section says it has to be in one person's ownership, and that person is sharing an interest, a portion of the ownership of the total, and putting it in an IRA for the spouse directly from the custodian of one to the custodian of the other. Now, the reason I became interested in this is I had a case, and in the case, the quadros or the IRAs weren't transferred on time. There was supposed to be a transfer within a certain number of months, didn't happen. So the wife figured, okay, then I'm just going to move this money into my the account at my office where they manage it for me. And she took several $100,000 and moved it to an account that her office ran. Fine, she thought it would be managed. I don't think it was ill intent. It may have been, but whatever. She just moved the money and had it managed by somebody else. Well, it turned out she destroyed the tax-free nature of these retirement assets. And she then wanted to move it back into an IRA. You can't move it back into an IRA. It has to be a direct transfer. It also has to be the same kind of account. It can't be a 401k. It has to be an IRA to an IRA for the spouse. We're still litigating it because nobody would believe me. And it's costing hundreds of thousands of dollars in tax. The tax can be subject to penalty because what she has done when she moved it out of an IRA into a 401k was she took an excess withdrawal. She took a taxable withdrawal. Okay, so it's in the 401k, but she has to pay the tax. And before she was 59 and a half, she had to pay a penalty on that withdrawal from her IRA. This really happened, and you cannot imagine the research that was necessary that brought me here. Okay, as to the recipient who was supposed to have money put into an IRA incident to this judgment of divorce, well, he couldn't take the money because there's an annual limit on how much you can deposit in your IRA. It's, I think, $7,500 a year. 8,500 now, 8,000.
No, seven and eight. 7,000 and 8,000.
Okay, approximately $8,000 a year that can be put into an IRA. Well, this was far more than $8,000, so he was not allowed to accept it. And if he did accept it, then the money in excess of the 8,000 would be would be rejected, and there'd be a tax plus a penalty every year on the amounts over 8,000. So the penalty is 6% per annum of the excess over the 8,000. This is very, very expensive and a huge mistake. So when you're doing an IRA rollover, which we look at as pretty easy compared to the quadros, we have this risk that it really must comply with the rules, that it be a transfer of an interest in the retirement, in the IRA. It must be a direct transfer so that it goes from one spouse or from the custodian or the manager of that spouse's account to the account of another spouse. It doesn't come out. If it comes out, we face this problem of taxation. Okay, and also it has to be incident to the judgment of divorce. It says judgment of divorce or separation instrument, but when you look closely at these, at the code, it says, no, it says pursuant to a judgment of divorce. So, okay, so we don't want to do the IRA transfers while the action is pending because we don't want to take that risk. Also,
Georgia, I have a question.
you can have questions.
Okay. I fear
Go
interrupting.
ahead.
So I agree. When I was on the grievance committee, one of the biggest areas of complaint were attorneys getting grievances because of quadros or retirement funds. My question is, number one, IRAs do not require a quadro.
Correct.
I have so many cases where you know, clients are divorced. They don't want to go through this crap. They don't want to pay me. They don't even sometimes want to talk to me. So, you know, I let them do their own, but I don't have, I miss Bob Granero. I don't have somebody now. So number one, do you, when you have a client, because a lot of the financial institutions still want a quadro before they'll transfer IRAs, and we all know that you don't need a quadro because it's a non-qualified plan. So what's your thoughts on that?
Go to a different institution where they don't request a quadro. They're allowed to ask for it for their own records. But the major ones, Vanguard and Fidelity, do not require a quadro. They understand that a transfer of an IRA is enough. They have these people sign insane waivers when the transfers are made. But I tell the clients, and I sort of walk them through it, that you each have an IRA, preferably in the same institution, because that makes it easier.
Yeah.
And you transfer enough to satisfy the agreement, which is usually half. And what you do is have the bank transfer from one account to the other account. And there's no time limit on that. They can do it. I think there's a 6-year time limit. It has to be pursuant to a judgment of divorce. And the judgment of divorce, and in order to be incident to the judgment of divorce, it has to be within 6 years of the date of divorce. Surprise.
So the easiest thing is to tell the non-participant spouse to just open up an IRA in the participant spouse's financial institution. But then my question is, Georgia, are you comfortable not having, you know, a pension expert do that? Do you do it
Yeah.
yourself, or
I
do you?
can handle the transfer of the interest of one directly into the interest of another without an expert. I can divide by 2 and say this amount of money must be transferred. And usually I'll be on the phone when they go to the bank and say, what happens now? And it's just a direct transfer of this certain amount of money. It has to be within 6 years. Who knows that? Nobody knows that. That when they define pursuant to a judgment of divorce, in some section that's not annexed to the other sections, it says that has to be within 6 years, unless, and then there are some unlesses. But we don't want to be involved in unlesses and in tax court. We want this done preferably in the first year, because there's a kind of a wide exclusion from tax if it's done in 1 year following the divorce. It's deemed to be incident to the judgment of divorce. So you want to do it fast. Also, there could be lots of changes, and you want to do it as soon as possible, because if somebody's changed the investment structure or withdrew or borrowed, you have a slew of other problems. And the faster we get it done, the better off we are. I know they don't want to talk to us, and they certainly don't want to divide money and part with it. But I try to get the IRA transfers done pretty soon after the divorce.
Thank you.
Yeah. And in terms of experts, we are really stuck there. I wanted to use actuaries. I don't know who has an actuary. Denisa might. Lexington does not. Troyan does in New Jersey. But it's very tough. And people who answer questions, they say they are quadro experts, but they're not actuaries, and they're not knowledgeable enough. What has happened, in addition to Bob Guarnera retiring, is that the plans, the institutions have stopped giving out the information.
Mm.
This was probably a huge burden on the various retirement asset. And they said, all right, you figure out how long the person was there. You figure out what Majowskis would be. You say what the benefit will be. Oh, the person took a loan. You put in who's responsible for the loan. You put in the death benefits. Majowskis doesn't have the death benefits part in it. So if you say pursuant to Majowskis, oops, big mistake, because you have to have death benefits listed as well. So it's a morass, and it's ours, because we can't just say, well, maybe we can. One of the things I wanted to discuss was, could we change our retainer agreements to say that there is a transfer of assets that requires an actuary or a specialist? And although we will refer you to that person, or maybe we even won't, we are not going to be responsible for completing that, because there are so many malpractice cases and evidently grievances about not completing the division of the pension, which is one of the largest assets in a divorce. I mean, we really should learn how to do this, but I don't know who's going to teach it. And we need those people who work for the public service institutions to do it. So I don't want any of us to use the Majowskis formula catch-all anymore. I think it's our job to put in the date of a person started working there and the date of the summons for divorce, and define how the denominator will be. Now, each of these things is not spelled out. For example, is it the date the person went to work, or the date the person became qualified to join the plan, or the date the person actually joined the plan? It's not clear. When you talk about the date of retirement or commencement, often there's a pre-retirement, early retirement bonus. Does that count as part of the time? Does it not count as part of the time? And this is a course and a half in law school to figure this out. And we're trying to do it as part of a divorce with the antipathy and the questions that I'm asking. If somebody borrowed against it and hasn't returned and has partially repaid, whose money is that? Whose share is charged with that? And there are cases on it that I read yesterday. And I found the reasoning unpersuasive, even though it's the appellate courts and court of appeals. There's a lot of litigation about the division of assets.
Georgia, my standard language is, as of date of distribution, plus or minus gains and losses. And what do you think about that language?
Well, I use a defined term, investment experience, because in addition to gains and losses, you have dividends, you could have stock splits. So I try to use a defined term, say subject to investment experience.
Okay.
Okay. But it's, there's always something we don't think of.
One
in the
person,
definition.
yeah, one person I wanted to mention who I believe is, besides Denisa and her group, for helping with the retirement plan division, is Chris Jinks. And she's in upstate New York, and she's excellent for some of the pension plans and the government area. So that's a good resource. But also, as far as sort of helping split out plans, because each different plans in IRA it could be a Roth IRA, and that has a different tax ramification, or it could be a 401k Roth. And for help with that sort of thing, you can turn to people like, I'm a CPA, Stephen Linker is a CPA, he's here. You can turn to people like that to help you in the beginning when you're first starting the case, kind of lay the groundwork for how to look at the various retirement plans, because their retirement plans, their pensions, they're non-qualified, they're qualified, as Kathleen said. So you might want to consider, consultants like CPAs, those of us that work in the divorce area, and then also consider somebody like Chris Jinks to help you make sure you've got the right language in the agreement to match what the decision is. So those would be some of the things I would have you as attorneys think about.
I
Thank
would like
you.
to add, I'd like to add that the time and the fee for, let's just say, consulting with one of us is very small, because we don't need to be involved in the entire divorce process. Even when you have a team, if the team is perhaps limited in certain knowledge, just call upon us to spend an hour or two doing what Sally suggests.
Thank you. Okay, and all of this has to be done before we write the agreements or before they're signed.
Absolutely. You've got to do it at the very start of the whole case, because depending on what you find and then how they agree, that's going to impact other assets. So yes, absolutely have to be done at the very beginning. I can't wait to the
Which
end.
means that when we do discovery, we have to get the plan summaries.
Mhm.
There's a case that says, look, you have to be specific with pension plans. That means you have to have the name right. They have so many different possibilities, and you have to say which plan. If you're talking about two plans and you're trying to do a quadro, they're different. There is one case, I think it was Court of Appeals, where there were four plans. They got it right for three. And one, they said, no, this was too vague. We're not dividing this asset. And so goes the malpractice claims. So we need copies of the plan summaries. We need copies of the choices of benefit. But IRAs are simpler. So let's go back to the simple one, which just says that it has to be within 6 years. It has to be pursuant to a judgment of divorce, and it has to be an interest in the IRA. Once you remove the money from the IRA, the interest is extinguished, can't do it anymore. So that means that there's a withdrawal by the owner who gets hit with taxes and possibly penalties.
Georgia, so is it your opinion that you can transfer 401ks before you get a judgment of divorce pursuant to a separation agreement or a stipulation, but you can't transfer
IRAs.
IRAs?
Yes.
Wow, that's
my
huge,
opinion.
Georgia.
Well, this opinion, which I divined.
I
a
will
long time
quote
ago,
you in my
came to-
next case.
Well, that's how it got interpreted. I lectured about it and I said, look, the way I read the statute, you can do it. You can do a quadro pendente lite. You can use it for counsel fees. You can use it to avoid penalties. And I presented Sam Fredman with a case and he signed it. So then I spoke to the Estate Planning Council. Everybody started using it. And it's used in Westchester and Putnam. where I know the judges, and I actually set forth the statutory interpretation. It was many, many years ago, maybe
So,
15 or
so
12
Georgia,
years.
just state it for us.
Um, let me send it to you because it's not so clear to me anymore.
No, I'm
It
just,
was,
the simple thing is, you can, if before you get a judgment of divorce,
divorce, you can
you
have
can
a quadro,
transfer
which is a court.
tax-free.
Oh, I remember. A court order has to be in the course of a matrimonial proceeding. For a quadro, it has to be in the course of a matrimonial proceeding. That includes an action for divorce. It doesn't have to be a complete divorce. And then it says spouse or former spouse. It says spouse. That means they're not divorced yet.
Right,
So this was the brilliant analysis.
it was brilliant.
Okay. And so they started allowing it. And now we use it a lot in Westchester. And if you go to New York County, you're out of your mind. They don't do it there.
So Georgia, what you're saying is that before I get a judgment of divorce, I can transfer 401k retirement funds tax-free, but not IRA funds.
Exactly.
Wow, that's
Exactly.
huge.
Okay. And you just quote me as a source. So no, I actually wrote this up. And I'll see if I can find it again and send it to you.
I think it'd be great if you sent it to everyone.
Yes, I will do that. Now, at the time, I wasn't sure what a matrimonial action was, and I thought it would include an action for support. It doesn't. But it also it's an action for separation or
Right.
annulment or divorce.
But I don't have to do an action for separation. I can do an
No.
action for divorce.
And you don't have to finish it.
Right. And end it with an agreement. Yeah, it doesn't even have to be a final agreement.
Doesn't even have to be right.
Yeah, what we're doing in our firm right now is we're not doing actions for divorce, we're doing actions for separation agreement, and I don't think that's necessary.
Yeah, I don't like the actions for separation
Mhm.
because you can't get equitable distribution in an action for separation. So
Right.
that doesn't work for me. But you certainly can get counsel fees and support by doing a division of the pension, the quadros.
Mm.
So we do it regularly. The courts in Westchester now accept that you can do a quadro during a divorce, and you can get counsel fees that way, and you can even get support that way. So yeah. Okay. Now let's.
Ken has a question.
Yes.
Oh,
I
Georgia,
didn't see you. Where are you?
hi there. Go to the next screen. Melissa and I have run into something here, and I had a
Ken,
situation.
I'm having trouble hearing you.
Can others hear me?
It's very low.
Let me turn up my volume.
Or just yell.
Not a yeller.
Never too late to begin, Ken.
That help at all? Oh, you know what? Where did someone pulled my, let's see. Does that help at all?
Oh, yeah.
Yes.
Okay. So the problem that we've run into, Georgia, is there's no uniformity between the 4 judges in the matrimonial part.
That's shocking.
And so Judge Carrie Fiore, when I had this issue in November, December, I dealt with her court attorney, Tara Monteleone, and they essentially refused to sign a quadro unless there were uncontested divorce papers. And so in that situation, we had anticipated the possibility and we got the papers in, and then they expedited signing the quadro because we needed it by December 31st. But I believe that Melissa has a case right now where the same judge in the same issue, and they're refusing to sign the quadro, and they scheduled they made her file an RJI, and oh no, I think you had to file.
Yeah, I
it
had
to
to,
get
but
the
it's a
judge's
preliminary
sign,
conference
but
and
they scheduled a PC. So Melissa's dealing with that right now.
Okay. The problem is they keep changing judges, and once the judge understands, he's gone. But I offered to get Melissa the law, and hopefully she'll be able to convince the judge that this is what we do, and we can give her a bunch of prior prior orders that were pendente lite and use quadros to pay legal fees and expenses. And maybe they'll listen because of the precedents. But don't try it in Manhattan. Now we have the new venue rules. Prior to that, I'd had people call and I'd say, okay, we'll just do this in Putnam or Westchester to get a quadro during the divorce signed. And so we had our choice of law by venue. We're not going to have that anymore.
I just have a question, I think it's 509, are they stayed or is it in effect, the venue rules?
I think it's going in effect very soon.
Yeah, okay.
Yeah.
It's 60 days after the signing of
Enactment, yeah.
legislation by the governor.
Okay.
The date that I've seen in some of the listservs is like February, you have up until February 19th to still be out of your venue, but after that, that's where it kind of gets questionable. So you need to do it before the 19th of February.
There's something else that's happening with these pension advisors. They're not giving us numbers. They give us words.
Right.
That this is what you should say in your agreement. But in terms of what is the equation, how many months or years, what benefits exist, we aren't getting it. We used to, but I understand that the plans have stopped giving that service. And so the experts have stopped giving that service. And I found with Lexington, actually, that I got back something that I could have pressed a button to get, which was the words for a quadro, but no specifics for that particular client. And we called and we said, what is this? And the answer is, that's what a quadro is. And they have now changed their website to say what they're giving. But we're not getting something that we can give to the court. It's not at all, it's not individualized. So we need somebody who will individualize it, or we need to know how to do it. And we need actual templates. But this is what this particular plan would require. There are a bunch of cases where there was a survivor benefit, and people don't pay attention to the quadros, and by the time they retire, somebody else, the second wife or the second husband, has rights that weren't considered at the time of the first divorce.
Yeah.
And I don't see any of the pension experts helping us with that. These are really complex actuarial and legal questions and accounting questions. So it's become much harder.
I think there's Lexington, there's Denisa. I like Carolyn D'Agostino, but other than those three, I'd be thrilled if other people would recommend.
Yes. And
because
Yeah, I
I
think
don't
So
know
I-
anyone
I
else.
still use Erica Guzman. So she used to work with David Gensler, who bought out Bob Guarnera. And I know that she's not an actuary, but she works with an actuary when she's preparing. I find her very responsive. I find her helpful, not just on language, but doing calculations. She'll talk with a client with me in the office. So I have found her very helpful.
Andrea, can you forward her contact
You
information?
bet.
Yeah, and besides Carolyn, again, there Chris Jinks is kind of in that category with Carolyn as well. So I have found Chris Jinks to be very knowledgeable.
Okay, yeah, I too am checking on somebody who I think is retired, but he might only be semi-retired. He's been around and is extraordinary. So I'll let you all know the story about that. His name is Martin Einhorn, Einhorn, and I'll let you know if he's still available. He's very good.
So for me, after Bob went out, I started using Carolyn a lot, and she was very knowledgeable about public pensions because she had worked, I think, as general counsel to the police pension. But she has not really been as active in that practice. And the gentleman who took it over is Robert Jones. And I don't know if you've worked with him. I think he's very good. He's an attorney. He's not an actuary. So if I have had to do present values of pensions, Denise Tova's firm has been able to do that for me, to present value a pension, to make a calculation as to what trade-offs there might be. But I really recommend Rob Jones highly. I show him all the language before I have an agreement signed. I'm not going to have an agreement signed unless I get his blessing on it, and he gets to see the plans and all the statements that are necessary before he passes on the language. That's kind of my best practice, is navigating this minefield. And it is a minefield, Georgia. We know it is.
Alan, I totally agree with you. You know, I think Carolyn's coming back. You know, she had a hiatus, but she's back. But we've used Jones and he's been terrific.
Great. Okay, so.
Georgia, can I ask a question real quick?
Sure.
In the retainers, have you adjusted yours? Because I'm just curious, like I know mine says this only pertains to this and does not include other actions, post-judgment actions, like for which a new retainer would have to be signed. So do you need to tweak the language even firmer than that?
Yes.
Andrea, I always put in my retainers that we're not going to handle the qualified domestic relations order.
Unless we sign a new retainer to do so.
No,
or something like that.
I don't even go into that. I just
Okay.
say, but if we do spend any time negotiating about it, you'll be billed.
Yeah, it would
Okay.
be great if we could say that this requires a specialty and perhaps even an actuary, but
But you know, Georgia,
it
it doesn't always require, like what's driving me crazy right now, I have a case with IRAs and it's simple. It's really simple. It's just whatever's in the account gets transferred to the other spouse. And we're paying Lexington and stuff thousands of dollars to do it. And
Why?
No
you don't
reason.
need to do it.
No.
There's no reason to do it.
Right. Right.
And yeah. Okay. They can just move the money to a different bank, a different institution.
Right. And I don't want to take the responsibility for them doing that. And they don't want to pay me for that. But, you know, I keep telling
But it's
clients,
much less
all
than
you have
paying
to-
Lexington. Because
What?
it's much less than paying Lexington. Because it's not a big deal. If it's going from within the same institution, just an IRA is easy.
And it can
They don't
always be
pull
the
the money
same
out.
institution because the non-participant just has to open an account
Right.
and they just transfer it. But anyway,
Now, one of them had a ridiculous waiver saying that in order to transfer money from one IRA to another, they wanted the clients to say that they would indemnify the bank for any tax consequences. And I had to litigate that my client wasn't signing that. But
wow.
we do have some absurd rulings. And you just have to make sure that it's really an IRA and it can be transferred. And, if the bank wants to talk to your accountant, let them, because their general counsel isn't so good at this. Okay, so speaking of pensions and assets, there are other assets that are hidden in the pensions and in the plans. There, or just in your employment, assets like payment for the last week before the summons was filed. It's an asset. Medical insurance, it's an asset. So if we are trying to divide equally, we could have them valued. And if we don't have them valued, at least they should be acknowledged so that in the discussion, we look at these extra assets. You look at the pay stub for the time the action was commenced and see what money was given just that was earned prior to date of commencement and received shortly after. You look at accrued vacation days. Oh, gee, that might be money. Accrued sick time, money. So in terms of dividing the assets, we want to look at all of these assets, which is why people want to hit me over the head.
Sure.
Yes, but it's
But I don't know, we have to balance
the
the
cost
hourly
and the
fee with the
delay.
cost of, yeah.
Yes, but if it happens to be a tier 1 medical benefits, it's worth a fortune. And it's overlooked until you say, okay, I want the couch. Aha, then we can trade. It's just be aware that it's a trading asset.
Mhm.
Right, and also that's a great point, Georgia, about looking at the pay stub. As a CPA, when I'm looking at income, I
Mhm.
don't care what's in the W-2. But I look at the pay stub and really do an analysis of that, and that can help you find the various benefits, and particularly with the government employees, you can find a lot of things. So that's a great point about the pay stub. Everybody needs to be looking at the pay stub. W-2s, yeah.
Why aren't the W-2s important?
Because the W-2s are only showing the taxable income and it's not showing all of the income. So looking at tax, so looking at the pay and also the pay stubs can help you find the benefits like vacation, overtime pay, workers' compensation, those kinds of things. Because you see it's all broken out there. You see the difference between wages and bonuses. You see the difference between wages and RSUs and other stock plans. So,
Sure.
so I
Health savings
highly
accounts.
recommend that.
Mhm.
Great. Okay. Quadros. So the information I have about the quadros and how we do it is that it is governed by federal law. And we may say in our retainers that it is governed by ERISA and should have an ERISA attorney if we're really trying to cover ourselves, or at least that we will be consulting with an ERISA attorney or accountant. Some of the cases talk about survivorship benefits, early retirement. What if we say something about the percentage of our quadro and person decides to retire early? Whose dime is that? Do we say that it should be deemed as if the maximum retirement benefit is going to be paid? Or should we say it's actual? Whatever happens, we've agreed that a share of the actual pension or a share of the payment will be made. This, okay, I just need us not to say Majowskis, because I got nervous when I was reading all of these cases. Early retirement, second spouse, incentive retirement, survivorship benefits. Survivorship benefits are different from rights to a pension. And that's what the courts say. No, Majowskis did not deal with survivorship benefits. Therefore, if you say Majowskis formula, guess what? Malpractice. And so we need these pension experts, or we need to learn what really is in each of these plans and what we have to provide for. The Court of Appeals said, if it's a loan, no, actually, I think it was Mark Dillon, it was second department. If it's a loan, it's intended to benefit only one person. So we're going to charge that person with it. However, if it's an early retirement, well, we're going to charge both with that. And I didn't follow where it said this in the law, but it certainly said it in the cases. And when we have a start date, don't say the day the person started, because you'll find out that there was a training period. Just pick the date. Give them a date and the number of months. Pick a date, because we'd rather have it as part of the stipulation of settlement than be arguing about it later on when it's time to divide the quadro. The date on which the action started, put down the date, figure out the number of days and months that we're saying were marital. Don't leave it as it's so easy. Well, we can easily say we'll follow Majowskis formula. Bad, because so many things are omitted. To the extent it applies, it's fine, but there are too many things omitted and it's risky. So the judges understand what we're talking about. It was great when we're in the Supreme Court, but it's not great when they go to implement it. Okay, what else should they? Okay.
Georgia, it's almost 10 o'clock and we only have until 10, and I'm just wondering, this has been terrific. I don't know how much more you have, but we also do have an opening for another pod presentation on February 19th, if there's a part 2. But tell me, how much more material do you have to go through? And do you want more
Depends on
time?
how details you want me to get.
Well, I think this has been amazing, honestly, and I think if you have more, I certainly welcome the opportunity to continue the
I
conversation.
always have more.
Okay, well, you're always welcome.
Well, thank you.
And we do, I don't know, just taking the pulse of the people in the room here. I, for one, have thought this was incredibly valuable and important information. And I'd rather not rush through, the next, well, actually, it's now 10. We do have something at February 19th, which is the third Wednesday of the month, from 9 to 10. And it would be great if we could maybe continue the conversation if you had more, and if you're available and if you have more to tell, and if people are willing to kind of participate and listen. And Kathleen, did you have a hand raised?
I would love February the 19th.
I'll get back to you.
I have another idea also, in addition, maybe because Kathleen and I have had experience with Rob Jones, maybe we would want him in to speak about how his approach is and maybe supplement some of the things that Georgia has given us as real minefields here.
Yeah.
How we deal with Majowskis versus putting other provisions in the agreement about the pre-retirement and survivor annuity, and give us maybe more of a base. I'd be happy to reach out to him and see if he'd be willing to do that.
That'd be great. I would love that.
That would be
Georgia, is that
wonderful.
okay with you? Will you share the screen?
Oh, I don't have to see his picture first.
Okay, well, you let us know then. You'll let us know. All right,
I'm sure he's good looking.
In that case,
Seeing everyone, I'm gonna log off.
Yeah.
Talk to
in
you
that case,
soon.
we'd rather have Alan.
Yeah. Thank you,
Well, I
Georgia.
thank you, Georgia, for saying
Yeah,
that.
and Georgia, can you share like what you referenced with Kath, you reference whatever that you referenced, if it's possible to share.
Yes, I will.
And you can share it with me and I can distribute it to
Yes,
the.
I will do
those-
that.
That would be
Yeah,
fantastic.
that'd
This
be
was like
great
really
too.
important, scary stuff. I'm now looking at, every time I attend these things, I get such nervousness with cases that have already been done or to be had. But this is good to make us aware and keep us informed, as you always do. It's been wonderful. And it was so great seeing everyone here.
Nice
Okay,
seeing you all
everyone,
too.
thank you so much.
Thank you,
Okay.
Have a great
Melissa.
day.
Thank you,
Well,
Georgia. Thank you, Alan,
Bye.
everybody.
Bye all.
Okay.